Hello everyone, my name is Salvatore Di Costanzo. I'm an elder law and estate planning attorney here in Westchester County, New York, with offices in Rye and Yorktown Heights. And I welcome you to another one of our Thursday chat lectures, if you would, on various topics. Today we're going to be talking about the guardianship process. I hope everybody's doing well. To those of you who've been watching on a consistent basis, I know that you've been finding these to be very fruitful. I hope you find today's lecture to be useful. It doesn't always apply to everyone, but you might know someone. And you know, it's always good to gather information and to listen to these topics, even if it doesn't affect you immediately, because in the future it might affect you and you'll have some knowledge and you'll know who to call. Want to start off by thanking all of our frontline workers, everybody out there that's doing their best to try to get us back to some sort of normalcy, and everybody just continue to be safe, be healthy, and do the right things. So today we're going to talk about the guardianship process. So you hear me talking often and really lecturing on a frequent basis about powers of attorney. You know, the power of attorney is an extremely important document that allows somebody to handle your financial affairs if you lose your capacity. And actually, it allows somebody to handle your financial affairs immediately upon signing the document. That's something that a lot of people don't realize. When does a power of attorney go into effect? In New York State, the power of attorney goes into effect immediately upon signing. So when you sign that power of attorney and you appoint, let's say, your spouse or your child to be your agent to handle your financial affairs, they can take that power of attorney and they can go to the bank, they can go wherever, and they can act on your behalf. You do not necessarily need to be incapacitated. You do not have to have a loss of cognitive abilities, right? So that's important for you to know. But a lot of people don't get down to drafting the power of attorney, regardless of how often I lecture about it, I write about it. I still have a plethora of people that don't come into the office to do their power of attorney. And a lot of times it's the older generations, it's also the younger generations. And if you don't have a good power of attorney in place, then you have to deal with the loss of capacity. You have to deal with what happens when you might need care someday and you cannot handle your financial affairs. That's the problem, right? That's the problem with not having a power of attorney, and also not having, you might have a power of attorney, but we want to make sure that your power of attorney is a good power of attorney. So many people come in and they say, Sal, I have a power of attorney, but I'd like to review it, and after I review it, I might say to you, this is just a very bland boilerplate power of attorney. It doesn't have gift-giving provisions. It doesn't allow somebody to move assets around. And those are the types of things that we put into the power of attorney as elder law attorneys. So the next step would be the guardianship process, right? So when somebody comes in, usually it's a child, might come in and say, mom or dad is at home, or even in a nursing home setting, and they've lost their capacity. They have dementia, they have Alzheimer's, some sort of cognitive impairment that really prohibits them from handling their financial affairs. What do we do now? Well, we can't sign a power of attorney, it's too late. If you don't have capacity, you're not going to be able to sign a power of attorney. So the next step is a guardianship proceeding. So we'll often look to a guardianship proceeding when somebody is in a nursing home setting or in a home care setting, and we need to move their assets around to apply for Medicaid. Other instances where we might consider a guardianship proceeding is where you might have someone at home and they're living, let's say, by themselves. They may still have their capacity, but perhaps they have poor insight and judgment from a lifestyle perspective. We've worked with hoarders. You see the hoarding disorder come up often, where people need a guardian to come in and take control of their affairs, so that way they can get out of the predicament that they're in. We also might consider a guardianship proceeding where somebody is being abused. whether it's physical abuse, financial abuse. That's becoming very popular today, unfortunately. Financial abuse, especially with the elderly, you've got different kinds of scenarios out there where you have investment advisors. You've got I'm not going to say banks and brokerage firms, but you've got individual advisors that take advantage of people. Perhaps they put them into the wrong investments. Perhaps I got a call last week where somebody invested $300,000 with someone, and this someone is no longer around, and they can't find the person. They have no statements. They have no records. These are real cases that we're seeing on a I'm not going to say regular basis, but more frequently than we would like to. So where somebody is unable to handle their financial affairs, and they might be being influenced or coerced, we might want to consider a guardianship proceeding. I've had cases where people call me up and a child is influencing a parent. Maybe a child lives with the parent in a mother-daughter type arrangement, and they become very close, and that child is pilfering the assets of the parent. And the parent doesn't have any type of cognitive impairment, but they won't believe that their child is doing something like that. And my child is in control of my finances. I trust them. But the reality is that the parent doesn't know that the finances are being dissipated. Perhaps the child is using those assets for their own benefit. So these are all reasons why you might want to consider a guardianship. It's not just when somebody is sick. There could be other influential factors that require us to think about a guardianship. Now, when you talk about a guardian and when you're considering a guardian, sometimes people call us up and we deny the case, or we turn away the case because a guardian isn't necessarily a solution for every problem. I had somebody call me up recently where mom and dad are living together, and dad is belligerent towards mom. He lives in his own little world, if you would. Sounds like dad is a mean person. Assets, I think the assets might have been separated to some degree, where dad had control of most of the assets. And mom was in a situation where she needed care, or we think she might need care, but she's really being, in many ways, she's being abused by her own spouse. But if we commence a guardianship proceeding to take control of mom's affairs, that doesn't necessarily solve my problem with dad. You see? So the people were calling us up and they were saying, we think we need to commence a guardianship proceeding. And they were even talking about a guardianship proceeding over dad. And I explained to them, it doesn't really work that way. Because if a guardian is appointed, we might be able to take mom out of that living arrangement. We might be able to take her out of that scenario. But it might not be the best solution to solve the problem. So guardians are not always the answer, right? In this particular case, it might be better for a geriatric care manager or a social worker, adult protective services, right? Sometimes we tell people to call adult protective services to intervene before we get involved with a guardianship. So you need to be aware of all these different factors when considering a guardianship. Now, let's say we decide that a guardianship is appropriate. Let's say we go back to our basic case of a Medicaid application. When you apply for a guardianship, you're asking the court for one of two types of guardians. Well, it could be both. A guardian over the person, meaning I can't take care of myself. I need somebody to help me take care of myself. Or a guardian over the property, which is, in essence, a substitute for a power of attorney. And depending on the facts and circumstances, we would analyze that type of case and craft the petition accordingly. But sometimes we might apply for a guardian just over the property. Sometimes we might apply for a guardian just over the person. Usually it's both, but we don't know until we sit down with the family and we go over the facts and circumstances. A guardianship proceeding is serious, right? It should not be taken lightly. What you're really asking the court to do is you're asking them to step in the shoes. You're asking them to appoint a guardian to step in the shoes of the person that is incapacitated, or should we say differently, has functional limitations, right? That's what the statute says. The statute says functional limitations. That means not necessarily that you are sick or ill or anything like that, but it could be any of these cases I just described where you may suffer severe harm if a guardian is not appointed. So it could be any of these cases that I described. Not all of these cases that I described have anything to do with cognitive impairment. Like I said before, it could be duress, abuse, influence, coercion, things like that. So you're asking the court to appoint one or both of those types of guardians. And it starts by sitting with an attorney, obviously. And the attorney would prepare a petition that lays out the story. You really got to tell the court the story. Here in Westchester County, we have 2 judges that sit in Supreme Court in the guardianship part. You don't know which one you're going to get, and they act a little bit differently. Each one has their own, way of proceeding with a guardianship matter. So you prepare what we call a petition, and you lay out the story. You lay out what the person is able to do, what the person is unable to do. You lay out all these factors that are important, whether it's an abuse or, and there are certain things that you can do in a guardianship. You could ask for restraining orders. You could ask for powers of attorney to be revoked. Sometimes we commence guardianship proceedings if somebody's abusing a power of attorney. So I started off by saying guardianships are common when there is no power of attorney. But there are instances where there is a power of attorney, but the power of attorney is being abused. And so you lay that all out in the petition. You tell the story to the court. The court gets that and serves the papers, well, you have to serve the papers on all the relevant parties. Who are the relevant parties? It's usually the family members, like a spouse, children. It could be the executive of a nursing home if the person is at a nursing facility. It could be the Veterans Administration if the person is a VA. So they're all parties that need to be made aware of this proceeding. And one of the parties is the Westchester County Department of Social Services, right? So everybody gets notice of this proceeding because you're asking the court to appoint somebody to stand in the shoes of a person that is suffering from functional limitations. And really what that means is you're going to be stripped of your constitutional rights. If you're determined to be incapacitated by virtue of a guardianship, you no longer can make your own decisions, right? So it's really important that all the necessary parties are made aware of this proceeding so they can come in and they can say something. They can object. They can say, I don't think this person needs a guardianship, for whatever reasons, and so forth and so on. The court then sets down a hearing date. And so we have to appear. So if I file the guardianship proceeding today and the court sets the hearing for July, we're in July, August, we need to appear on that date so that way we can actually have a trial. A guardianship proceeding is an actual trial. So when we appear on that date, you need to bring the incapacitated person to court. A lot of people don't realize that. So the incapacitated person shows up in court so that way the judge can assess and see with his or her own eyes that the person is in fact in need of a guardian. And we actually go through a trial. Who represents the incapacitated or the alleged incapacitated person, right? Before we get to the trial, the person is alleged to be incapacitated. We then have to prove all those allegations at the court. Once we prove that, the person is then determined to be incapacitated by the court. So who represents the incapacitated or the alleged incapacitated person? Well, the court usually appoints mental hygiene legal services. Mental hygiene legal services is an outfit in New York State that represents people that are generally without means to represent themselves. usually our nursing home cases, our home care cases, mental hygiene is representing the incapacitated person. If you're someone that is not suffering from functional limitations, you can hire your own attorney, right? So in the case I gave before with the husband and wife scenario, you're free to hire an attorney. Let's say the husband wanted to hire an attorney. He could hire an attorney on his behalf and defend himself, right? Those are litigated guardianships, contested guardianships, and they get pretty hot and heavy at times. So we have this hearing, and the incapacitated person or alleged incapacitated person needs to be there. Mental hygiene can actually dispense with that person's presence. So let's say somebody is suffering from Alzheimer's and is really out of, has no capacity. Mental hygiene can say to the court, this person cannot meaningfully participate under no circumstances. Please dispense with their presence. We don't want to put them through any kind of burden, and that happens often. So we have this hearing, we have witnesses. Family members get up on the witness stand and we take their testimony. So it might be a spouse or it might be a child. And we say to them, who is this person? Your father? Yes. Tell me what you observe about this person. Tell me about the living arrangements. What does it look like on a daily basis? If it's one of these Medicaid cases, we might say, can he bathe by himself? Can he feed himself? We go through all your typical activities of daily living, and we make the case. When that case is done, when that trial is done, and if there are no further objections, the court is going to rule on the case. And often we find that the court rules in our favor, and a guardian is appointed. And then there's a series of paperwork that needs to be done after the fact to finalize the guardianship and actually get the guardian officially appointed, almost like an executor of a will. And we have to do all that paperwork, and it takes some time, and unfortunately, costs legal fees. So this is, generally speaking, what a guardianship looks like. And I want you to be able to take some of this information and go back to your own personal situations and see if it applies to you, right? Sometimes people think that when somebody has lost their capacity, there's nothing more that we can do, but that's not true. We can go through a guardianship. Sometimes we can go to a guardianship and just ask for a specific purpose. For instance, let's say there's a house that needs to be transferred for Medicaid eligibility purposes. I could commence a guardianship proceeding and ask for the sole power to transfer that house. We don't have to go through a full-blown out guardianship process. And why would I want to try to avoid a full-blown out guardianship? Well, because post-hearing, there's a lot of things that need to be done. The guardian might need to take educational classes. The guardian needs to post a bond. There are accounting requirements that the guardian needs to do. So you don't just show up in court and say, I want to be a guardian, and that's it. You've got to go through this process, and it's a continuing process, which is lengthy, and it's sometimes burdensome. It depends on the facts. So in a Medicaid planning scenario, we could go to the court and say, we just need to do this. And the court might give us permission to do that. We prove to the court that we transfer the house, and that's it, we're done, right? So we could simplify the process. So you may have a loved one that needs Medicaid, or it might even be on Medicaid and has lost their capacity and has done nothing to protect their house. I just wrote a blog about protecting your house today, actually. That's going to be published. You should consider a guardianship so that way we can protect the house. You might know of a situation where people are living in squalor and you want to try to help these people. In a hoarding scenario, we might petition the court for a guardian, and what are we asking the court to do? We're asking them to appoint a guardian, but then we're asking the guardian to put together some sort of care management plan where we'll work with social workers and geriatric care managers and organizers. If you've ever watched that show on TV with the hoarding cases, you'll see that there are professional organizers that come in, and we would do this under the supervision of the court in a guardianship proceeding, come in and help try to put the individual that's suffering from the hoarding disorder on the path to, a better lifestyle. So we might have people come in and slowly clean out the house. We might have people come in and help with their finances. We might need somebody to take control of issues that might arise with the police department, the fire department, the local municipalities. There could be all different kinds of complaints that have been filed for fire hazards and nuisance complaints, etc. All different kinds of things. And we can come in with a guardianship and try to take care of those situations. So a guardianship is very, very useful. It does take a while to be carried through, and it does cost money in legal fees. And that's why a good power of attorney can solve the problem or save you from having to go through this, what could be a nightmarish process. A simple power of attorney drafted properly can avoid having to go through a guardianship proceeding to appoint a guardian to handle the same things that could be handled by a power of attorney. So when I tell people draft a power of attorney, I hope by listening to this guardianship lecture, you really can understand more fully what I'm talking about and what I mean when I say a power of attorney could be one of the most important documents that we draft for you. It avoids the necessity of a guardianship proceeding. So that's about all for today. There's a lot more to talk about when it comes to guardianships. But I just wanted to give you a flavor for what it looks like. A lot of people don't realize what it means to go through a guardianship proceeding. And when I tell you draft a power of attorney to avoid a guardianship proceeding, a lot of people don't really understand that. So I'm hoping that this brings some light to the situation and forces you to call me or another attorney up to do your estate planning, especially during this pandemic. We want to make sure that you've got the proper documents in place to avoid future problems. And we surely have been seeing a lot of problems over these last few months. If you enjoy watching these lectures, which we will continue on an every other week basis, and we might take a little bit of a pause for the summer because it seems to be kind of slowing down a little bit during the summer months where people go away on vacation and so forth and so on. But generally speaking, we do these every other week, so every other Thursday, and I sometimes bring other professionals in to talk about their experiences in their particular fields. But it would also be nice if you would send me an email and tell me what you might want to hear about. If it's relevant, I'll do it. If it's something that I don't think really works, I'm going to tell you as well. Somebody recently sent me an email and we ended up having a conference call. So not every topic is right for these types of lectures. But if you send me an email, it will make my life easier because it doesn't force me to have to think about a topic. So I'm happy to be able to communicate back to you whatever it is that you would like for me to speak on. Visit my website, Plan Today for Tomorrow. There's a lot of useful information on my website. These videos are posted to my website as well. And then you can read blogs, you can watch these videos. There's a lot of great information over there. Please share this on social media. If you like this, please share it with your friends so that way other people can join us and we can increase our followers. And you could reach me at 914-925-1010. That's my office number. That's the RIDE number. Yorktown is 914-245-2440. And with that being said, stay safe and stay healthy, and I look forward to doing this again. Take care.